I'll be okay.
All rise. All rise.
Good afternoon, please be seated. Here's the case CR 2025-548, State of Ohio versus Darnell Jones. We're here today to begin the adjudication in this court of the charges against Mr. Jones. I will go over those charges and death penalty specifications and cover a lot of other necessary ground today. Let the record reflect Mr. Jones is present today as our assistant prosecutors, Ms. Latigue'S Wilson, Ms. Cook, Mr. Klukas, defense attorney David Klukas. Mr. Jones, of course, is here with his and by them I also mean Ms. Baronis, who is here. Court staff, members of the press, security personnel, and members of the public. This hearing is being preserved for the record by Sarah, our court reporter. And as I said, we've got a lot to cover, so I ask for everyone's patience, perseverance, and best behavior. Mr. Jones, there's a lot of people here today. You can tell. I can appreciate if you're anxious or if you're nervous. I want you to do your best to focus on me and the questions I'm going to ask you and the information I'm going to give you, okay? Now, as we said, I have a lot to go over. I want to make sure you understand. That's the key, okay? What's your name?
Darnell.
What's your full name?
Well, I go by Ogletree, Darnell Ogletree. Maybe I had as Jones.
Okay, can you explain why do they have Jones? Why do you call yourself Ogletree?
My birth name is Darnell Ogletree, and my adopted name is Darnell Jones.
But does your birth certificate say Ogletree, or does your birth certificate say Jones?
Jones.
It says Jones.
Yeah, but like my social security card, my ID, all my taxes, everything been under Ogletree,
Where were you born?
Ohio.
Where were you raised and where do you live?
I live in Cleveland, Columbus, and Toledo, but mainly Toledo.
Are you a United States citizen?
Yes, sir.
Okay. And can you speak, read, and write English?
Yes, sir.
Do you speak, read, or write any other language?
No, just English.
Just English, okay. And do you have any problems reading, hearing, seeing?
No.
Do you wear contacts?
Sometimes I wear reading glasses, but.
Okay, well, there's gonna be some stuff to read today. And for instance, we have an indictment, you can see on the big screen there, the screen in front of you, I'm gonna be reading part of that. So if at any time you need help with anything, please let either your attorneys or let me know, all right?
Yes, sir.
How about hearing aids, anything like that?
No, sir.
You hear me okay?
Yes, sir.
I'm gonna ask you that you speak up when you can, okay? Are you taking any medications?
Just pain meds for the accident, and they got me on some psychotic meds, like anxiety.
For anxiety?
Yeah.
Okay. Are you taking those medications pursuant to a doctor's order?
Yes.
Okay, are you taking them according to those instructions?
Yes.
Or, do those medications affect your ability to understand what I'm telling you?
No, sir.
Does it affect your ability to answer my questions?
No, sir.
Okay, once again, if I go too fast or you don't understand something, just let me know, okay? Have you been diagnosed or treated for any mental illness?
Yes, sir.
What kind?
Depression, schizophrenia, bipolar, ADHD, ADD. It's been a lot. Can't name it all.
I don't want to get too much into your personal medical records, but the reason I'm asking you this is, I want to make sure, and I'm sure your attorneys want to make sure you're understanding what I'm asking you. That's the only reason I'm asking you right now, is to make sure that if you have any kind of medical condition, physical condition, handicap, it doesn't impair you from answering my questions and understanding what I'm talking about. Okay? Agree?
Yes.
All right. We need, as I said earlier, to review some very important matters, starting with your right to counsel, your right to an attorney. You have the right, Mr. Jones, to hire your own attorney with your own money. You have the right to represent yourself, which I highly discourage in the strongest terms I can tell you, or to ask me to appoint for you an attorney. Now, if you wish to hire an attorney with your own money, I'll give you time to do that, a reasonable amount of time so you can get some money together and hire an attorney. Now, if you hire your own counsel, there is no requirement that he, she, or they be certified to handle what we call a capital case, a case involving the possibility of the death penalty. The record indicates that you were over in municipal court before Judge Nicole Curry, and at that time, I believe the court had appointed you a public attorney. Is that right? Okay. Now, I anticipated that you might be asking me to appoint you an attorney or attorneys over here. That's why we contacted Mr. Lucas and Mr. Coronas to see if they would be willing and able to represent me in that. Now, the reason we contacted them is because they are both certified by the Supreme Court of Ohio to represent defendants in cases like this. Both of your attorneys, who may be your attorneys, but if you want me to appoint them, are so certified. Now, I would appoint Mr. Lucas as your trial lead counsel and Mr. Coronas as trial co-counsel. Now, in anticipation of your appointment, Mr. Lucas, I believe you met with your putative client.
I have, Your Honor, on 3 occasions, and Ms. Baronis has also met with him as well.
Have you prepared an affidavit of indigency?
I have filed an approach.
See that the financial disclosure form has been completed, and I want to ask you, Mr. Jones, I know you say you go by Ogletree, but you signed your name Darnell Jones, correct? Okay. Is your signature right there? All right. Court finds the fact, given that what you have reflected in your form, that you are in fact indigent. Court approves. Have to read it. The entry that the court issued setting this arraignment and appointment of counsel hearing references a discussion that your attorneys and attorney for the state of Ohio had with me in chambers that was on April 24th, I believe, earlier this week.
Yes.
That entry, I think a copy of that entry is on the table in front of you. It looks like this. Counsel, I'll ask Ms. Punk, Ms. Wilson, is there anything you'd like the record to reflect that beyond what is in that order of what we discussed in chambers?
No.
Lucas?
No, Judge.
Do you have any questions about that, Mr. Jones?
No, sir.
Now, I know Mr. Lucas went over this with you. I want to go over it with you too. As you know, Mr. Jones, Mr. Lucas's son, London Lucas, who's here in the courtroom, is an employee of the Lucas County Prosecutor's Office. Did you know that? You understand that I'm going to be ordering your attorney, father, Mr. Lucas, Dave, not to have any communication with his son, London, about this case. Do you understand?
Yes.
You so agree?
Oh, absolutely. Yeah.
Okay. Ms. Liptak Wilson, Lawyer Office, wall off London Lucas from any participation in the investigation, research, strategy, discussion, and any and all facets of the prosecution of the case.
Yes, Judge, we will ensure that takes place. We've had discussions with Mr. London Kuklitz already. We also put in place some security measures in the online case management system that the case documents will be uploaded into.
Thank you very much. Mr. London Lucas, I'll ask you, will you agree to have nothing at all to do with the case and take affirmative measures if necessary to absent yourself from any discussion whatsoever about the case?
Yes, Your Honor.
Okay, thank you, sir. Now, given what I just heard, Mr. Jones, I find that there is almost certainly not a real conflict of interest here. And any potential conflict of interest now has been avoided because of what you heard them promise the court that they're going to do and not. Okay? I want to ask you, sir, if you're certain that you yourself are satisfied that Mr. David Lucas can continue to represent you.
Yes, sir.
All right. Do you have any questions and concerns about that? You understand that father and son will see each other,
Yes, sir.
probably be at family events and dinners and maybe go to a Tigers game or something like that together. You understand that?
Yes, sir.
You understand that any father and son will be talking with each other about various things, right?
Yes, sir.
Okay. Now, they promise not to talk about the case in each other's presence, even directly, at any time. And in fact, Mr. London Lucas will be walled off from any participation in this case while he works for the prosecutor's office. You understand that?
Yes, sir.
Are you okay with that?
Yes, sir.
All right. If you want some time to think it over, I'll give you that time. If you want me to appoint another attorney for you, I'm happy to do that. But since you're willing to go forward with Mr. David Lucas as your attorney, I see that he has provided to the court a waiver in writing, which I'm showing you here from the bench. You seen this document before?
Yes, sir.
I think a copy of it might be on your council table as well. On the second page, I'm showing you here from the bench, Mr. Jones. Is this your signature?
Yes, sir.
Okay. I'll make sure that that waiver of potential conflict is resolved for the record of the case. Have a couple of questions now, Mr. Jones, for your attorneys, okay? So I'll ask Mr. Lucas, Ms. Baronis, please confirm you are both certified to be appointed as trial lead counsel pursuant to the rules for appointment of counsel in capital cases.
I am as well, Your Honor.
Please confirm that you will remain so qualified throughout the entire pendency of this case.
I will.
I will also.
Please confirm that your law offices are located in Ohio.
Mine is.
Yes, it is.
Please confirm that your workload outside this case will allow you ample and sufficient time to devote to this case and that this case will, when necessary, take precedence over your other professional obligations.
Absolutely.
That is correct.
Okay, thank you. Mr. Klukas, as trial lead counsel, please confirm that you will bear overall responsibility for the work of the defense team in this case.
I will.
And both of you, I'll ask, will you endeavor to provide high-quality representation of Mr. Jones throughout the case?
Yes, we will.
That's correct, Your Honor.
They are very well qualified, Mr. Jones. They have been certified by the Supreme Court of Ohio to handle death penalty cases. I want to make sure that you're confident in your attorneys, okay? Would you like me to formally appoint them for you today?
Yes, sir.
So ordered. If during the pendency of this case, counsel, it's necessary for me to appoint additional attorneys, please bring that to my attention.
We will.
Your Honor.
On your table, counsel, I have the appointment of trial counsel form, which is required to be filed both in this case and with the Supreme Court. I think I may have misstated Ms. Coronis's address since she moved offices.
I just moved in the last 3 weeks, Judge. We'll correct that.
Okay, if you would please, and then return the case, or return that form to me. I'll have it filed with the case and filed with the Supreme Court of Ohio. I would also order our clerk of court to file a notice of filing capital indictment pursuant to revised code 2929.02 K. Captain Cromet, welcome. Thank you for coming. I got a couple questions for you, sir. Can the Lucas County Jail provide Mr. Jones and his counsel with appropriate accommodation in which to meet privately and confidentially throughout the case?
Yes, Your Honor.
Okay. Will counsel need to make any advance arrangements to meet, to show evidence, discuss evidence, et cetera, with Mr. Jones?
We'd appreciate a little notice, based on our security measures. Call the Corrections Administrator's Office to advise your arrival time and things in a day.
Will do, yeah. I mean, there may be some instances of spontaneity, but for the most part, yes, we can do that.
Mr. Crum, or Captain Crum, excuse me, are there any security issues which would preclude Mr. Jones from appearing in the courtroom without restraint and in civilian clothing that you're aware of?
None that I'm aware of, Your Honor.
If there are any medical conditions on behalf of Lucas County Jail, Captain, will you please, under seal, provide any medical information the court needs to know about?
We will.
Okay. And share that, of course.
Over.
City Council.
Always.
Okay. Captain Schnur? Any security concerns that you would like to have addressed today?
Given the high-profile nature of the case, we are asking that once the proceedings have started, that we don't allow the additional members of the public in at each session after the proceedings have started. Also, that we would like to, we will be prohibiting, or we would ask the court to prohibit spectators from loitering in the hallways during the proceedings. The court has taken steps to broadcast the proceedings on the televisions on the first floor, and we ask that to be a reasonable accommodation for the public to have access to the trial or for any proceedings once the court is open.
No. Can you check it from the state?
No.
We are now, and we will continue in the future to broadcast all proceedings in this case for anybody who cannot fit in the courtroom, which is not the problem today, we have empty seats. But we will be broadcasting everything to the 2 monitors that are on the first floor by the snack shop. It's an amply sizable space for any member of the public to come and use, so that we can ensure that Mr. Jones doesn't have a secret trial, but they do have a public trial that you're entitled to. Do you understand that, sir?
Yes, sir.
Okay, good. I would also endeavor to hold future hearings, pre-trials and the like on Friday mornings at 9, so as not to interfere with the other business being conducted in the court. Wednesdays, this is an off one for us because I wanted to make sure that we had the arrangement as soon as we could. But going forward, I would anticipate using Fridays at 9, okay? Right. Council, do you have any questions of either Captain Coleman or Captain Schmidt?
We do not.
Any from the state? Okay. Let's go to the arraignment. As you see on the screen in front of you, Mr. Jones, and there's actually a paper copy that you've been handed right now, is the indictment. Usually, the reading of the indictment is waived, and Mr. Lucas, I believe you would have no problem with the court waiving the full reading of the indictment?
No, in fact, we would offer a waiver of the reading of the indictment.
What I'd like to do is to then, rather than read the whole thing word for word, which will take us a half hour, I want to go over with you the nature of these charges, because I want you to know them so that you have as much information as you need to deal with your attorneys, you can ask them pertinent, intelligent questions, and all of that, okay? All right, so let's begin. And the direct, as I said, it's on the screen too, if that's easier for you to read that one. All right, so the indictment has a case number on it, has your name on it, and has some operative dates. This indictment, Mr. Jones, contains in it 15 different counts. Count is simply a charge that you violated. Let's start with the first one here. You've got count 1, aggravated murder, UF means unclassified felony, with specifications. It alleges that you did purposely and with prior calculation and design cause the death of Keimani Latigue in violation of those code sections, making it aggravated murder. Now you're going to see beneath that felony murder specification, which alleges that you committed, attempted to commit, or were fleeing immediately after committing or attempting to commit rape, and either the offender, you were the principal offender in the commission of the aggravated murder, or if not the principal offender, you committed the aggravated murder with prior calculation and design. The specification under that also says felony murder. It's the same as the one I just read with the replacement instead of rape, it says kidnapping. And the third felony murder specification replaces rape or kidnapping with aggravated burglary. Otherwise, those three specifications are essentially the same. You'll see on the next page that there is also a murder to escape specification, which reads that the offense was committed for the purpose of escaping detection, apprehension, trial, or punishment for another offense committed by you, to wit, rape, kidnapping, and or aggravated burglary. Although that is what's called a sexual motivation specification, and it says that you committed the offense with the sexual motivation. Finally, it says sexually violent predator specification, saying that you are a sexually violent predator. Count 2 says all of the same things, essentially, other than it alleges that you did purposely cause the death of Keimani Latigue while committing or attempting to commit, or while fleeing immediately after committing or attempting to commit the offense of rape, aggravated murder, unclassified felony. You'll see the same essential specifications: felony murder times 3, the murder to escape specification, and the other 2 specifications that were attached to count 1. I won't read those again for you. With your client, attorney rather, waive reading. Going to count 3, which is another aggravated murder charge, alleging you purposely caused the death of Keimani Latigue while committing or attempting to commit kidnapping. You'll see the same specifications in count 3 as you saw in counts 1 and count 2, with the names of the offenses changed where appropriate. And then there's count 4, which is the last aggravated murder charge against you. It reads similarly to the ones I just read. Okay. Move down to count 5. Count 5 is different. It's rape, a felony of the first degree with specifications, which alleges that you did engage in sexual conduct with Keimani Latigue when you purposely compelled her to submit by force or threat of force, constituting rape, a felony of the first degree. That charge has a sexually violent predator specification, as you can see below. Count 6 is similar. It alleges it's a count of rape with a specification. It alleges that you did engage in sexual conduct with Keimani Latigue while you purposely compelled her to submit by force or threat of force. Again, rape or felony of the first degree, and it's got that same sexually violent predator specification. Count 7, it's on the screen, is a count of kidnapping. It's a felony of the first degree with specification. Now that alleges that you did, by force, threat, or deception, remove Keimani Latigue from the place where she was found or restrain her liberty for the purpose of engaging in sexual activity with Keimani Latigue against her will, in violation of the law, constituting attempted kidnapping. Furthermore, the victim of the offense is alleged to have been under 18 years of age. That kidnapping charge carries with it both the sexual motivation and sexually violent predator specifications. Count 8 is also a kidnapping charge, alleging that you did by force, threat, or deception remove Kei'Mani Latigue from the place where she was found or restrain her liberty for the purpose of facilitating the commission of rape or flight thereafter, also constituting the charge of kidnapping, a felony of the first degree that has the sexual motivation and sexually violent predator specifications attached to it. And you'll see in count 9, that's the third kidnapping charge, alleging that you did by force, threat, or deception remove Keimani Latigue from the place where she was found or restrained her liberty for the purpose of terrorizing or inflicting serious physical harm on Keimani Latigue or another violation of the revised code. Also kidnapping, a felony of the first degree with the same 2 specifications as the other 2 kidnapping charges. When we get down to count 10, it's now aggravated burglary, a felony of the first degree. Now that alleges that you did by force, stealth, or deception trespass in an occupied structure or in a separately secured or separately occupied portion of an occupied structure when Keimani Latigue, a person other than the accomplice, was present with the purpose to commit in the structure or in the separately secured or separately occupied portion of the structure any criminal offense to it, rape, and you inflicted or attempted or threatened to inflict physical harm on Keimani Latigue, constituting the crime of aggravated burglary, felony of the first degree. Counts 11 and count 12 are both endangering children. They're a little bit different, so I'll describe each one to you. The first count, that is count 11, of endangering children, alleges that you did abuse Keimani Latigue, a child under 18 years of age with whose birthday provided, constituting endangering children with a furthermore clause that the violation resulted in serious physical harm to Keimani Latigue. And the other endangering children charge, felony of the second degree, count 12 of the indictment, alleges that you did torture or cruelly abuse Keimani Latigue, a child under 18, constituting endangering children, and that the violation resulted in serious physical harm to her. Okay, count 13, gross abuse of a corpse, felony of the fifth degree. That count, Mr. Jones, alleges that you did, except as authorized by law, treat a human corpse in a way that would outrage reasonable community sensibilities, constituting gross abuse of a corpse, felony of the fifth degree. Finally, with counts 14 and 15, each of them is a count of tampering with evidence. Each of them is a felony of the third degree. Each of them allege that you did, knowing that an official proceeding or investigation was in progress or was about to be, or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation in violation of the law, constituting tampering with evidence, a felony of the third degree. As I said, counts 14 and 15 are essentially the same. Did you understand what I read? How do you plead?
Not
Let me see if I can be a little more precise. Okay. So, with respect to count 1, Judge, to the charge of aggravated murder on behalf of Mr. Jones, we offer a plea of not guilty. To the 3 felony murder specifications, the 29-2904A7 specifications, we offer pleas of not guilty. To the murder to escape specification, we offer a plea of not guilty. To the sexual motivation specification, we offer a plea of not guilty, as well as a plea of not guilty to the sexually violent predator specification. Likewise, for count 2, to the substantive count of aggravated murder, we offer a plea of not guilty. To the 3 felony murder specifications attached to that count, we offer a plea of not guilty. To the murder to escape specification, it's a plea of not guilty. Sexual motivation specification, we offer a plea of not guilty, and a plea of not guilty to the sexually violent predator specification. With with respect to the substantive count and the charged in count 3, the aggravated murder, we offer a plea of not guilty. To the 3 felony murder specifications attendant to count 3, we offer a plea of not guilty. To the murder to escape specification, we offer a plea of not guilty, as well as a plea of not guilty for the sexual motivation specification and the sexually violent predator specification. For count 4, it's the same process to the substantive count, not guilty. To the 3 felony murder specifications, not guilty. Murder to escape specification, not guilty. Sexual motivation specification, not guilty. And the sexually violent predator specification, not guilty. Because those first 4 counts are capital offenses, I believe it's appropriate to enter a plea not only to the substantive count, but to each specification. Beginning with count 5, we don't have a capital charge. So what we're going to do is offer a plea of not guilty to count 5 and the attendance specifications. As to count 6, we're going to offer a plea of not guilty to the count and the attendance specification. With respect to count 7, we offer a plea of not guilty to the substantive count and to the 2 attached specifications. With respect to count 8, we offer a plea of not guilty to the substantive charge of kidnapping and the 2 attendance specifications. Count 9, we offer a plea of not guilty to the substantive count of kidnapping and the 2 attached specifications. We offer pleas of not guilty to counts 10, 11, 12, 13, 14, and 15.
Thank you, counsel. Those pleas are entered into the record. Going forward with this case, Mr. Jones, you have now, and you will have throughout the rest of this case, a number of rights. I don't have the ability to go into great excruciating detail with you about those rights, but I want to go over them generally. And your attorneys later can answer any questions you may have about them, okay? All right. You have the right to counsel. We talked about that already. Counsel has been appointed for you. You are presumed to be not guilty of the charges and specifications brought against you. You have a right to a trial by jury of 12 persons who must be unanimous in their verdicts. You have the right to have the state prove your guilt beyond a reasonable doubt as to each element of each charge and each specification. You may waive your right to trial by jury and opt to have a 3-judge panel try the case instead of a jury. You have the right to confront any witness who testifies against you at trial and have your lawyers cross-examine them for you in the courtroom in your presence. You have the right to what we call compulsory process, which uses the subpoena power of this court to allow you to have any witness you want to testify in this case for you on your behalf to be brought in here to testify for you, so you can call that witness. You cannot be forced to testify against yourself at trial, and if you chose not to testify, your silence could not be used against you in an attempt to prove your guilt. You have the right to be present at every stage of this case. You have the right to hire the services of experts, with the court paying the bill for them. You have the right to present evidence and mitigation at the sentencing phase of this trial. Again, these are a generalized version of your rights. Do you understand? Okay. Remember, you can ask your attorneys at any time if you have specific questions about any one of these rights. Okay?
Yes, sir.
Okay. Now, as you know, death penalty specifications have been a part of this case. That means this case will be divided into 2 parts, the trial phase and the sentencing phase, if necessary. At the trial phase, the jury or the 3-judge panel will determine whether the state has proven beyond a reasonable doubt all of the elements of the charges and the specifications. If you are found not guilty of them, you will be released. If you are found guilty of the offenses, but not guilty of the death penalty specifications, you will be sentenced to a term of years in prison corresponding to the charges and the non-death penalty specifications that you were found guilty of. If you are found guilty of one or more of the death penalty specifications, which we also call the aggravating circumstances, and that or those aggravating circumstances are not outweighed by factors which mitigate against the imposition of the death penalty, the jury will return the death sentence. In this case specifically, Mr. Jones, it's alleged that the aggravating circumstances, as you just heard me read through the indictment, are that you committed aggravated murder and rape, kidnapping, and or aggravated burglary, and or that you committed aggravated murder with the purpose of escaping detection of having committed rape, kidnapping, or aggravated burglary. Now, the crime of aggravated murder is not by itself an aggravating circumstance. Factors mitigating against a death sentence lessen or eliminate the appropriateness of the death penalty. They can include your age, your upbringing, your criminal history, duress, your mental condition, frankly, just about anything else can be a mitigating factor. The crime itself may, in fact, be a mitigating factor. If we get to the sentencing phase, you have essentially the same rights as you do in the trial phase. If you wish to make a statement at the sentencing phase, you may do so either sworn or unsworn. If you make a sworn statement, you'll be subject to cross-examination by the state's attorneys. If you make an unsworn statement, you won't be subject to cross-examination. The jury will have to decide whether the aggravating circumstances outweigh the mitigating factors. If they find that the aggravating circumstances outweigh the mitigating factors and conclude beyond a reasonable doubt that they do, they will return the sentence of death. It is then up to me to make my own determination based on a similar weighing process whether the death sentence is appropriate. If I agree with the jury, I will impose a death penalty. If I disagree with the jury, I will impose a sentence of life imprisonment. I may not impose the death penalty if the jury declines to impose it. All jurors must agree before a death sentence may be imposed. Likewise, if you choose to have a 3-judge panel instead of a jury trial case, a single judge can prevent the imposition of the death penalty. However, if all 3 judges agree to impose the death penalty, it will be imposed. And if the death penalty is imposed, this case will automatically be appealed to the Supreme Court of Ohio. So my explanation of your rights and the long procedures concerning these charges, as I said, is basic and general. As with anything involved with the law, there are many complicated details and exceptions. I just don't have time to go over all of those with you now. I just want to give you a preliminary basic outline, okay?
Yes.
All right. Ms. Wilson, Ms. Cupp, you want to be heard on bail. I know you filed a request with the court in writing. I don't know if Mr. Lucas and Mr. Holmes have had a chance to review it.
I have.
Yes.
Thank you, Judge. Pursuant to Article 9, Section 1 of the Ohio Constitution and the case law referenced by the state of Ohio in its motion filed this morning, the state is requesting that the defendant be held without bail or bond.
Doesn't that section of the Constitution require that the proof is evident or presumption greater of the commission of the offense by this defendant? And then you want to offer the court, for the court's consideration to satisfy that prong of the constitutional requirement.
Not at this time, Judge. We'll turn to counsel for the defendant to see if they have anything they would like to offer contrary to that at this time.
Very well. Mr. Lucas.
Judge, as the court indicated near the beginning of this proceeding, Mr. Jones is indigent. Quite frankly, bail is something of an academic issue here. There is no bail that the court is going to set that is commensurate with this case that Mr. Jones is going to make. I don't necessarily agree entirely with what the state has posited in their motion, but I do agree that Article 1, Section 9 does provide a basis to hold without bail. But I think that the case law that the state cited, there's basically one meaningful case, and it's the Reed's case. And it does say that the court can make this decision based only on the return of the indictment, but it also leaves us the opportunity to return at a later date. And I guess what I wanted to say here is that we would like an acknowledgement from the court that if the court chooses to hold Mr. Jones without bail today, that it acknowledges that the applicable law does give us the opportunity to come back and overcome that presumption. So right now, I don't really know enough about Mr. Jones to make an intelligent bail pitch. I know what kind of case it is. I know what the means are to post a bail. So I really don't have anything other than the legal argument to acknowledge that we can come back to offer the court by way of argument on bail.
Yes, sir. We've not received any discovery yet from the state, I presume.
I've received nothing. In fact, technically, I explained to Mr. Jones that until this proceeding is over, I'm not entitled to it. So,
Okay. The point is well taken, Mr. Lucas. I'm going to have the defendant remanded without bail, reserving for the defense the right to readdress bail at any time in the future. We, as I said, we'll be here having regular pre-trials, motion hearings, and other court events throughout the pendency of this case. And at any time, if you'd like to readdress bail, I ask that you do so in writing.
oh, absolutely.
And that was the time, of course, for the state to respond. Okay, thank you. Let's go over the Buchanan speedy trial. Mr. Jones, you have a constitutional right and a statutory right to have your case tried speedily. I would ask whether the state has a date of arrest from which we can begin counting days.
Just one moment, Judge.
Sure.
March 25th, judge was taken into custody in Columbus, Ohio. Then April 17th was brought into custody here in town.
Thank you. Mr. Jones, you have the right to be brought to trial within 270 days of your arrest. But since you've been in custody continuously, each day in jail counts as 3 days. That means you have the right to go to trial within 90 days from the date of your arrest. You have a separate constitutional right to a speedy trial based on a number of factors that I would have to consider. You may waive your rights to a speedy trial after you've discussed it with your lawyers in order to provide you more time to both investigate and prepare the case for trial. Mr. Klukas, if you had a chance to discover or discuss with your client the issue of time waiver.
We did. I did.
And would your client be willing at this time to waive his rights to speedy trial, or would you like time to think?
No, we are in a position to execute a limited waiver of time. It's not going to be like till the end of the case. Now, how far we're going to waive kind of depends on the next scheduling steps. The court had indicated that if you wanted to do pre-trials on Friday, what we had contemplated and what I had discussed with Ms. Baronis and Mr. Jones is a 60-day time waiver, at least for 60 days for now, for us to take the temperature of the case and get some discovery and start some motion practice and get some funding. And we feel like that's a legitimate reason to waive speedy trial for 60 days. That's what we had discussed with Mr. Jones. I kind of thought the court might set a status pre-trial out that long, but I'm getting the impression that perhaps you may want to see us before then.
Well, I was going to suggest that we get together on Friday, May 23rd. We have a lot of housekeeping matters to take care of. We have some scheduling matters to take care of. I'm sure you'll be filing motions galore. We'll have those that will be in some form for the court's consideration.
What I'm going to suggest with that additional intelligence is that we are willing to execute a time waiver up to and including Friday, June 27th, which can then be a scheduled pre-trial date. That's a Friday. And we will re-examine time waiver at that time. But I think the court's correct. I think there's going to be a lot of tolling episodes here. And we would probably prefer to let those do the tolling rather than a waiver. But for today, we are willing to waive his right to a speedy trial until Friday, June the 27th.
If you look on your desk, you'll find a draft of a time waiver that the court has prepared. And I'd ask you to please, if you haven't already, read through that, discuss it with your attorney or with your client. You'll note that the very last sentence says, the time waiver shall not be due to date certain. You cross that out and write to June 27th, sign initial.
That sounds great. Yeah, we're willing to do that. Yeah.
Okay. You need a moment with your client?
We need a moment to do a little editing, but the time waiver itself has already been discussed.
Okay. Once the waiver has been prepared, signed by both client and counsel, I'll ask you to put your Pam gets it, we'll file it. With the case. I have a question now for the prosecution, this Jack Wilson or Todd. Who in this case seeks to act as the victim's representative under Marcy's law?
I believe it will be the victim's grandmother, Dorothy Latigue.
Is she present today?
Yes.
Has anybody else applied or spoken up with the desire to be named by the court as a victim's representative?
No.
Thank you. Question for both sides now, if I may. Is there any objection to a gag order prohibiting counsel and all others acting through or on behalf of counsel and parties from making any public statements regarding the case, unless, of course, those statements are made on the record while court is in session, and also from providing any information regarding the case to any person, media, or other entity?
I believe Ms. Baronis and I are of the same opinion, which is we are not in the habit of making public statements anyway. So the order that the court proposes is fine with us.
No objection from the state.
The court will then order, it will issue a written order to that effect, and of course, Mr. Jones, so you understand the purpose of the order is to limit the effect of pretrial publicity and ensure that this case is tried right here in this courtroom, not out there in the community. I anticipate, as you all know, many motions and other documents will soon be filed. I'll be issuing some housekeeping orders regarding those, but for now, I would direct the parties to alphanumerically sequence their motions. I think there may have been some filed already, so we may have to back number those. The defendant will use numbers, the state will use letters, the court will use Roman numerals. We have a number of friends here in the media. Pam has provided you with a copy of Superintendent Rule 12, which will govern the recording, broadcasting, and photography of court proceedings. Our court administration and our courtroom staff can assist you with any issues. If you'd like to be kept up to date on scheduling, please make sure that Pam, my criminal bailiff, has your email address. Because sometimes at the last minute, we have to reschedule things and maybe have to come all the way down here only to find out that at the last minute we had to waste time. I would ask kindly that you refrain from broadcasting images of Mr. Jones outside of the courtroom and at any time that he might be wearing restraints in order to preserve the jury pool and, of course, Mr. Jones's presumption of innocence. Okay? Thank you.
Your Honor, if I may approach with the signed waiver.
Oh, thank you. Filed, and thank you. All right, Mr. Jones, we're going quite a lot today. Do you have any questions? We're going to be seeing a lot of each other in the coming weeks and months, and I want you to keep me posted of how you're doing. I want you to keep me posted on not what you're talking to your attorneys about, because that's protected information. I can't know, they can't know, the media can't know. You're entitled to absolute confidentiality of your attorneys. But if there's any breakdown, if anything that needs to come to my attention, I want you to make sure you tell me, okay?
Yes, sir.
All right. Now, there's gonna be times when you're gonna be frustrated, angry, you name it, right? I get that, that's all, we all experience that. You're experiencing it most acutely given the situation we're in now. If there's a major and insurmountable issue, bring it to my attention. And anything that you want to share with the court, you have to share it through your attorneys, unless you're sitting here where you are right now, right in front of you, okay? Mr. Lucas, Ms. Baronis, do you have anything else from the record today?
Nothing more from us, thank you.
Ms. Tech Wilson, Ms. Buck, anything? All right, we will be adjourned, and we will see you all on Friday, May 23rd at 9 a.m.
Hold on, I want to go downstairs.